Hello students, this is Professor Del Russo, and this is a basic general overview of matrimonial law. When New Jersey law is referenced, I will specifically say so. The legal effect of a divorce is to end the marriage. The marriage is over, people are restored to the status of single people. It also involves the division of property, spousal support, child support, and child custody and visitation. By end of the marriage, we mean it's over. As I said a moment ago, it returns everyone to the status of single persons. The next issue in divorce law is the division of marital property. And other than child support, custody, and visitation, this is probably the most sophisticated part of divorce law. Now, you have to focus on what's called marital property. Marital property is all property that was acquired during the marriage. Any property that was acquired before the marriage, for example, an inheritance or bank accounts or some other asset that either spouse has before they get married, is considered separate property. And we call that separate property whether you are in a community property state or an equitable distribution state. Now, how we divide up marital property varies among the different states. The minority of states follow community property law, and there's about 9 states that follow community property law, and that means that in those states, the spouses are deemed to equally own all income and assets that were acquired during the marriage. Now, this means that both the husband and the wife are deemed to equally own all money earned by either one of them during the marriage, even if only one spouse has a job. Also, all property acquired during the marriage with community money, commingled money, money that they have in a joint bank account and that they pool together, is deemed to be owned equally by both the wife and husband, regardless of how much money they contributed to that pool of money. In a community property state, equal ownership also applies to debts. So this means both spouses are equally liable for debts. In most cases, this includes the unpaid balance on credit cards, home mortgages, and car loan balances. So one way to think about it is, in a community property state, you divide up the marital property 50-50. That's the rule. Okay, that's a little bit simpler than an equitable distribution state, as you will see in a moment. And that 50-50 applies not only to marital property, but also marital debt. Now, the remaining states, the vast majority of states, follow equitable distribution law. Now, there, the analysis is a little bit more complex. In an equitable distribution state, the division of marital property is based upon each spouse's relative contribution to the marriage. And that requires some degree of analysis. What someone contributes to a marriage is not that easy to figure out. The court has to look at a number of factors to decide how marital property is divided up. Now, what an individual spouse receives when the marital property is divided can vary between 1/3 and 2/3. So what does the court look at when deciding who gets what in an equitable distribution state? Well, as I said, it's based upon contribution to the marriage, and the court will look at the financial condition and the earning power of each spouse, where they work, how long they work, how much they get paid. They'll look at the value of each spouse's separate property. That includes the spouse's business interests, any retirement plans, pensions, 401k, stocks, bonds, etc. Remember, there's this stuff called separate property that may have been brought to the marriage, or even within the marriage, sometimes a piece of property can be considered separate property. So the court looks at how each spouse is financially, what their condition is, and the value of all the property they have, even that separate property. The court also looks at the degree to which each spouse contributed to the acquisition of the marital property. the degree to which each spouse contributed to the education and earning power of the other spouse. So while one spouse was making money, the other spouse may have been getting an education or contributing to the education of the spouse that was earning money, which increased that spouse's earning power. You know, a spouse with a graduate degree can make more money than a spouse who doesn't have a graduate degree, and so on. If someone went on to get a master's in business or a law degree, and the other spouse contributed to the acquisition of that, the court's going to look at that and factor those facts into their decision making. The future financial needs and liabilities of each spouse will be examined, the ages and overall health of each spouse, how liquid marital property is. Is it something that can be cashed out now, or does it require that it be held for a while before you can reap the benefits of that property? And that matters to the court. Any premarital or prenuptial agreements will be examined by the court, and any spousal maintenance or alimony obligations. So the court does a precision analysis of each party's financial condition and how they reached that financial condition, how they contributed to the acquisition of that wealth or the creation of any debts. So to sum up, in equitable distribution states, there are no hard and fast rules about who receives what and how much. The court looks at all kinds of factors to make that decision and attempts to be as fair as possible. Another issue in matrimonial law is spousal support. This is also complex, perhaps more complex than division of property. There are local rules, and there are court-made rules, and there are statutes, and there are the peculiar facts of each case that comes before the court that govern the outcome in spousal support. There are 4 kinds of spousal support that are recognized in New Jersey, and I'm giving you the New Jersey examples here. Alimony, rehabilitative alimony, limited duration alimony, and reimbursement alimony. Alimony usually applies in a situation where there is a long-term marriage. The parties have been married for 30, 40 years or so, and one spouse did not earn as much as the other spouse, significantly less than the other spouse. Perhaps they were a homemaker, or they worked part-time, or they had a job that simply didn't earn as much. The court will award payments to the less economically advantaged spouse in an effort to have both parties live as reasonably close to the standard of living that they enjoyed during the marriage. So again, the goal is for the parties to live as reasonably close to the standard of living that they enjoyed during the marriage, so that one party won't be living in a mansion and the other party living in a one-bedroom walk-up apartment. The goal is to try to even things out as much as they can, and the court will award a financial payment, usually on a monthly basis, to the less economically advantaged spouse. However, sometimes there are marriages of short duration, and the court might order what's called rehabilitative alimony or limited duration alimony. Perhaps the parties are young, they've been married for generally less than 10 years, and the court will, in the case of rehabilitative alimony, order an amount to the less economically advantaged spouse in order to allow them to obtain what they call economic self-sufficiency. And so the alimony is paid for a particular or specific amount of time until they can get a job, get skills that are necessary for that job, maybe go to school, maybe increase their ability to earn money. And it's not about maintaining the marital lifestyle. Sometimes one party may have postponed their education to raise a family. Well, then rehabilitative alimony would allow them to go to school and then eventually get a job till finally they are economically self-sufficient, and then the alimony would cease. That's similar to limited duration alimony. Rehabilitative alimony is a form of limited duration alimony. And again, limited duration might apply to short-term marriages. It has its own specific rules that apply. For our purposes, realize that it is a specific term of alimony that eventually ends. It's not unending. Now, there has been recent legislation in New Jersey that has attempted to stop alimony from being never ended, even in long-term marriages, relatively long-term marriages. And I'm not going to get into that. Suffice it to say, the longer the marriage, the more likely you're going to get alimony for a long time, perhaps the rest of your life. It all depends upon your age and a number of factors. Your age at the time of divorce, and how long you've been married and what your relative relationship is, and those kinds of things. Reimbursement alimony is another form of alimony. That's for a specific amount. It's less common than the others, where one party may have to pay back the other party for support for an advanced education. Maybe one party paid for graduate school and then law school, and that party, in order to make things equitable, argues to the court that they need to be reimbursed for what they contributed in a marriage that is also probably of short term. Again, this is complex stuff. Suffice it to say, it usually involves one spouse with a financial need and the other spouse with the ability to pay. And the court's goal is to be fair and equitable and treat both parties in an equitable way. The other thing, and perhaps most important to us in Children in Justice, is the notion of child support. When a couple divorces, both parents remain financially liable. The non-custodial parent, the one who doesn't have the children or child in their home, is usually required to pay support to the custodial parent, the one who has the child or children in the home and takes them to school and soccer practice and those kinds of things. Child support is a significant issue in all cases where you have minor children who are not completely emancipated in a marriage. And related to child support are other issues involving the treatment of the children when there's a divorce, and that is who gets the children, child custody that is, and what does visitation look like in a case where there is a breakup of the parties, yet one party deserves visitation. This too, like most things in matrimonial law, can get rather complex, and they are always fact sensitive, but there are basically 5 kinds of custody arrangements that the law recognizes. There is sole legal custody, and that means that one parent has the right to make important decisions for the child. For example, the parent with sole legal custody has the authority to decide where the child goes to school and whether the child should receive medical care. On the other hand, you have sole or primary physical custody, and that means that one parent has the primary right to physical control of the child. The parent with sole physical custody, often called the custodial parent, that's the parent with whom the child lives most of the time. The custodial parent does most of the day-to-day parenting. This includes getting the child up and ready for school, taking them to the doctor, for example, driving them to music lessons, tucking them in at night. This parent, the one with sole physical custody, often, although not all the time, has sole legal custody as well. And we just talked about sole legal custody a moment ago. That's the ability to make legal decisions about the child, where they get medical care, whether they should get braces, whether they shouldn't get braces, whether they should go to a Catholic school, a Christian school, a private school, public school. If you have sole legal custody, you get to make those kinds of decisions. And often the person with sole physical custody also has sole legal custody. However, in some cases, one parent has sole physical custody and the other parent shares legal custody with that custodial parent. And that takes us to joint legal custody. That means that parents share the right and responsibility to make decisions related to health, education, and welfare of the child. It doesn't matter if the child's living with parent A. Parent B, who doesn't live with the child, still has a right in a joint legal custody arrangement to make decisions about the health, education, and welfare of the child. Now, there's something called joint physical custody. It seems hard to do and it's never perfect, but that means that each parent has significant periods of physical custody. And with minor children who have to go to school, That's difficult to work out unless both parents live right near one another. Then that could work out a lot better. If the parents live in different regions of the same state, then it becomes a little bit more difficult. But if they live in the same neighborhood, then the child could spend week 1 and 2 with parent A and week 3 and 4 with the other parent, and they can still get to school because they all live in the same neighborhood. And then you have something, the last one, called joint legal and physical custody. And that means parents share physical and legal custody. That's where parents divide up taking care of the child. The child lives in 2 residences, typically, and both parents have legal custody as well. They can make fundamental decisions about that child's welfare, their health, and their education, and those kinds of things. Now, let me share a little bit more with you about custody issues and focus on what Professor Myers teaches us in his textbook. Professor Myers explains that joint custody in one form or another is a good solution for divorced parents who can cooperate. But when there's friction and animosity between the parents, joint custody seldom works. When one parent accuses the other of child abuse, well, the chances of successful joint custody are really small. Now, in the typical divorce, one parent gets primary custody, as I suggested a moment ago, and the other gets visitation. Visitation, by the way, is a legally enforceable right. It's not a privilege. It'll be in the court order, and it's a legally enforceable right. Visitation is granted automatically unless the non-custodial parent has engaged in serious misbehavior, such as child abuse or criminal activity. Now, the divorce decree usually describes the visitation schedule of the non-custodial parent. As I said a little while ago, the custodial parent has no right to change that schedule on their own. Now, if for some reason the custodial parent believes that visitation must be stopped, well, that parent must return to the court and ask the judge to modify the visitation schedule. A person who has custody simply can't cut off visitation. Now, up until about 20 or 30 years ago, many states had custody laws that favored mothers of young children. This maternal preference was called the tender years presumption. The tender years presumption. The belief was that young children were usually better off with their mother. Today, the law has changed. It's become more gender neutral. The fundamental rule of child custody law today is that a child's mother and father have equal rights to custody. Therefore, in a dispute over custody, the parents begin on equal legal footing. Neither parent has an advantage over the other. The equal right to custody applies whether or not the parents even married. So, custody, visitation are complex issues. I'm not going to get any more into this other than to say that each case is different, obviously. What's fair and what's appropriate has to be based upon the particular and peculiar set of facts that a court is listening to. Everybody's got a different lifestyle, different approach, different jobs, different children, different age ranges when a divorce is filed. So the court has to look at all aspects of the case before it makes a decision on custody and visitation. There is plenty of case law out there that gives us the answers whenever a conflict comes up, but every now and then courts make new law when it comes to these issues. In any event, that was just a brief overview to introduce you to how children are involved in the matrimonial justice system. Lastly, let's take a look at how to get a divorce, and we will use New Jersey as an example. For very many years, in order to get a divorce, you had to prove what was known as a cause of action. You had to prove one of a list of things in order to get a divorce, and the problem with that was it often led to battles in the courtroom because there had to be a decision by a judge after a trial, unless the parties agreed otherwise, in order to prove the allegations. And they were very emotionally charged battles. With the advent of the no-fault divorce or irreconcilable differences, we don't have to worry about that as much anymore. But in the past, you had to prove adultery or desertion or extreme cruelty or the fact that you were separated for 18 months or more, or voluntary substance abuse or mental health institutionalization, or one of the parties was imprisoned, or one of the parties engaged in what was known as deviant sexual conduct. None of those causes of action are used with much frequency anymore because of the no fault divorce or irreconcilable differences. Irreconcilable differences was a game changer. Now we took out most of the emotion surrounding divorce, especially those that would occur during litigation. And irreconcilable differences, in essence, means that you can't get along anymore, and that these irreconcilable differences have lasted for 6 months or more, which is very easy to prove. It has been equated to no fault divorce, and it makes things a lot more smooth and a lot easier during litigation. So while you still can plead a cause of action in New Jersey, there really is no real need to do such a thing. And the easiest path to getting a divorce is the no fault divorce or irreconcilable differences. Now, in the past, people who wanted to get a divorce right away and get into the courtroom right away would plead one of the allegations like adultery or cruelty. And when the litigation took longer than 18 months, they would often ask the court to change the basis for their cause of action to 18 months separation, because so much time had elapsed during the litigation that they could modify it. The problem was emotions were still heated because although there was no trial, you still had to include in your pleadings a number of allegations which gave rise to whatever the cause of action was. You'd have to spell out in black and white in your paperwork what the act or acts of adultery were, or what the act or acts of desertion were. And that is not a good way to start this process at all, even though ultimately the cause of action could be modified to 18 months separation. So no one has to get into that anymore. And as I said earlier, things are a lot smoother when it comes to getting a divorce in New Jersey. Now, one last thing to think about: alleging any of these causes of action do not give you an advantage in any of the other issues surrounding divorce. For example, equitable distribution or spousal support or child support, and rarely even in child custody and visitation. So it is the belief that by alleging adultery, it might give you an advantage in how the court views the distribution of property or even spousal support. That's not the case in New Jersey. Alleging these acts does not give you any advantage. Now, there might be some very rare situations where adultery might impact upon spousal support, where during the adultery, perhaps the spouse who committed adultery spent a lot of money on his or her person who they were cheating with, and that dissipated the assets. There, it's not so much the adultery. It again focuses on the assets, and sometimes the adultery itself might diminish the assets and therefore might be indirectly relevant. But the mere fact that you've committed some bad act rarely comes into play. It might come into play in child custody or in visitation, because sometimes the act is so bad that it might impact upon the children's development. If the act involves child abuse or domestic violence, that may impact upon visitation issues and the like. But for the most part, the law is no fault, and even bad acts do not change the equation in a divorce matter.